Walter, put up the other backdrop. All right. I think we have, is it just us so far? All right. Oh, we have attendees here. Here we go. Hello, Deborah. Hello, Jovina. Hello, Teresa. Me too. Welcome. Teresa, good to see you. Welcome to the HR Roundtable. Let people file in here, file in digitally, and we'll get ourselves up and running. This is the first time we've done an afternoon session. All right, welcome, welcome. Walter, I don't know if you sent the 10-minute warning this time around. Welcome, David. All right, we'll give people a few minutes to file in here before we get started. Hi, Francis. Welcome. All right, welcome everyone. Barbara, good to see you. All right, welcome to the HR Roundtable. I think I'm going to flip over and share my screen to free Walter up to send out another last-minute blast to people. All right, here we go. Hi, Sonia, Lynette. Barbara, welcome. All right, well, we are going to get started in a couple of minutes. We've got a great presentation for you. And welcome to the HR Roundtable, which is a pretty much a monthly seminar series brought to you by the 10 Positions group of companies. We've been doing it for many, many years. My name is Roger Oliver. I'm the Director of Strategic Accounts at 10 Positions. And I've been running this forum for senior HR professionals for many years so that we can sort of arm people to the teeth with the kinds of information that they need to really be able to earn their place at the table with the C-suite. So we bring you the top information, the most up-to-date information to make sure that you are always firing on all cylinders. And I'm just going to go ahead and get things rolling. So before I introduce our speaker, Andrew Singer, just a little bit about 10 Positions itself. We are a multifaceted staffing solutions firm. We do temporary, temp to hire, and direct hire across a really wide range of skill categories. You'll see our divisions here are all branded with a name to reflect the discipline being covered. So account positions is our division for accounting and finance. CompuForce for a full range of IT professionals and solutions. HR Staffing Solutions is our human resources division. So we have all major disciplines of HR covered there. Lots of action in the not just only the generalist positions, but a lot of contract recruiters being requested these days, as you can imagine. On-call counsel is our legal division. So we do attorneys and paralegals, as well as other legal professionals. We have a large educational footprint, school professionals being the flagship. We do substitute teachers for charter schools and private schools. And we also have the exclusive arrangement with the city to provide pre-K teachers for what was Mayor de Blasio's signature legislation of universal pre-K. So all of those community-based organizations that are running preschool programs funded by the city, when they're not able to find those UPK teachers, pre-K teachers on their own, which is all the time, that redounds to us. So we're the engine under the hood of the New York City UPK program, largest school system in the country. Convention services, sort of an offshoot of our hospitality division, but in this case, everything geared towards trade shows. Our hospitality division provides both front and back of the house staff, waiters, bartenders, and culinary professionals. We have a large footprint in the healthcare space, working with a lot of social service organizations that provide services to people with developmental disabilities, child welfare, shelter programs, and others. And we are also staffing the Vaccinate New York initiative for the entire state of New York currently. So all of the folks working at those large intake centers and pods throughout the state, we're very proud of that. Our logistics division, this is pretty much everything having to do with all those boxes showing up at our doorstep for the past 2 years, all the hands that go into getting things where they need to go, as well as customer service and some of the other services that those organizations need. And lastly, our office support division for just general office support and clerical needs, and the creative bureau for creative artists for design and production and all things web. So we've got a great program for you today. One of my very favorite speakers here, Andrew Singer, who has done presentations for us for many years. Andrew is the managing partner of Tannenbaum Halpern and the chair of the firm's employment law practice, which offers a full spectrum of legal services from everyday counseling to complex employment litigation, with an extensive experience in all aspects of employment law that he regularly advises companies and various human resource and compliance issues. So everything from issues of basic employment, draft and negotiation of employment agreements and executive comp structures, regulation and compliance of all kinds, wage and hour, independent contractors, HR policies such as social media policy, anti-discrimination, the WARN Act, and then also litigation and dispute resolution. Andrew is a frequent speaker on employment topics and emerging trends, and regularly conducts trainings for all different types of HR and employment issues. And Andrew's been selected for inclusion in New York Super Lawyers for looks like every year running since 2010. So with that, I will leave you in the very capable hands of Andrew Singer. Take it over, Andy. You can go share your screen. And
thanks, Roger. Appreciate the the kind words. That introduction seems to get longer every year with all the different employment laws and things that we have to do as employment lawyers. Appreciate that. And hello, everyone. It's always nice to present to the HR Roundtable. Been doing it probably for maybe a dozen years or so, give or take. With the pandemic, maybe it's equivalent to 15, 16, 17 years, but thanks for attending today. Today's topic actually is relatively simple. There's some new amendments to New York labor law and the whistleblower statute there, and I'll go over a little bit of the details. But what I want to emphasize first is we have seen really a lull in the amount of employment claims from employees, whether it be lawsuits, governmental charges filed, demand letters from lawyers, from the beginning of the pandemic, probably through the end of 2021. We have seen a meaningful uptick in employee complaints, workplace investigations, lawsuits, and the like since the beginning of the year. And not entirely sure why, just factually speaking, it is happening. And it just adds to my concern in educating our clients about this law. And you'll soon find out why. And so everything that you know about best practices, education, training of employees, of management, mid-level management in particular, is so much more important today than ever before. And so if you're going to leave today with just one takeaway, that really would be it. Make sure that you are training at all levels for everything that you're required to, and even things that you're not, because that is going to help minimize the risk that we have as employers today. And as I indicated to Roger, there's more laws coming, and it's not going to end anytime soon. So more compliance, more regulation, more things that HR teams have to do, what you're responsible for. It's this race between California and New York now. New York joined that. California was always viewed as like a foreign country when it came to national employment laws, but now New York really is there. New York City in particular. So let's. Oh, and by the way, please, any questions along the way? Don't. Is that something they can do while we're?
Sure. Yes. The
program, Roger,
if you want to use the Q&A tab there along the bottom.
Sure.
To put your questions in, and I will field them and make sure that.
Great. Let's make sure we're doing that.
Yeah.
That's always helpful. if I can answer them, terrific.
Yeah. And
they often questions sometimes lead to other questions and a good dialogue.
Absolutely. And since we've got a relatively tight group of us, feel free to ask multiple questions, folks. You've got Andy all to yourself today. So
rare occurrence.
Yes, indeed.
Okay, so New York Labor Law, Section 740. There's a few amendments. Let's talk about why it is that we're here today. So it is new. So this really didn't come about until this year, January 26th. And it really enhanced the employee whistleblower protections and certainly new requirements for New York employers to make sure that they're in full compliance with the law. The amendments expanded who was considered an employee under this statute to include former employees and independent contractors, so that now there's far more number of individuals that can bring these kind of claims. Tremendously broadened the scope of the protected activity, and I'll talk more about that in a few minutes. No longer require the employee to first notify the employer in certain situations, and expanded the types of actions considered retaliatory. Most importantly, it expanded the employee remedies. So there's far more damages now that can be awarded, including punitive damages and entitlement to a jury trial, which is in New York, particularly downstate here in the New York City area, not very friendly to employers. So this is a major change to the law. In fact, I've been practicing for just a tad over 30 years at this point, and I have yet to handle a New York whistleblower claim. I've only had one that was filed against a client, and we got it dismissed. It was just not appropriate under the statute. It is a statute that has been rarely utilized. It has been incredibly narrow and just irrelevant in the scheme of employment law. Never really talk about it. It just wasn't something that any employees or plaintiffs' attorneys decided to try to take advantage of. And here's why. So prior to the amendments, the key here is, and if you look in Romanet 1, the key is the violation of law, rule, or regulation that the employee thought was at issue. It had to create a present a substantial and specific danger to the public health or safety, or which constitutes healthcare fraud. So in the healthcare space, there was some of this, but otherwise it had to be a law, rule, or regulation where the public health at large was in question, right? Not a lot there. That's incredibly narrow. And so we really didn't see any of these claims. That is now completely changed. The new amendments removed the requirement that an employee's ability to successfully seek recourse depend on both an actual violation and a substantial and specific danger to the public. Here's what it does now. It relies only on an employee's reasonable belief that such a broad violation has occurred, or that such action poses a safety threat to the public. So now it's an or, so forget about the safety of the public as a requirement. It's just now a reasonable belief of an employee that there's some violation of law, rule, or regulation. That's it. That's a tremendous difference in the standard here. And I am absolutely anticipating as soon as the plaintiff's bar figures this out and how to use it, I do believe there's going to be a tremendous amount of these kind of cases filed going forward. It's just, there's going to be a tipping point. Once the plaintiff's bar sees a few of these things filed, get past a motion to dismiss, I think we're going to see a lot of this. So let's talk a little bit more about the specifics. The new amendments define retaliatory behavior as an adverse action taken by an employer to discharge, threaten, penalize, or in any other manner discriminate against any employee or former employee exercising his or her rights. So what does that include? Actions or threats to take such actions that would adversely impact a former employee's current or future employment adverse employment actions or threats to take such adverse employment actions against an employee in the terms of conditions of employment. And that clearly includes discharge, suspension, or demotion. And then threatening to contact United States immigration authorities or otherwise reporting suspected citizenship or immigration status. Here, really any adverse actions, such as, because these are the obvious, I want to talk about some not so obvious, a performance problem, right? Someone makes a complaint that they think there's a violation of law occurring, and all of a sudden, an employee who has a pristine performance record within a few weeks of that complaint, now suddenly there's performance problems that are being documented, put on a PIP, where the employee's been there 7 years and has been nothing but a good performer. Anything like that. Someone now is transferred to a different division, different agency, different part of the company, moved offices, not getting overtime assigned to them. Any aspect of that person's employment where they're suddenly being treated differently in a negative way. It can be that broad. And there's other areas in the law that are, talk about adverse employment action the same way. Anything, a lot of the retaliation laws with respect to discrimination in the workplace, very similar in that regard. That's why I mentioned in the beginning the need to properly train management. We see so many of the claims that are filed where there is merit. There are problems with actions or inaction taken by mid-level managers. They're just not trained. They don't see how their actions could create liability. And so that's a real emphasis today more than ever, is that training. In particular, when you're communicating now in this remote environment, more than ever electronically, email, texting, and other forms of communication, that is considered, it's more casual, right? By virtue of a text, it's people's mindset is not necessarily to treat it as a business communication. And that just reduction in awareness that this communication is a business communication leads to problems that occur. And here, usually, if there's an employee who is complaining about, hey, I think, that violates a certain law or rule or regulation that we're supposed to comply with, and they're told, no, we're fine, and then they raise it again. It's really untrained management that will get angry, and then they'll put emails or communications out there expressing the anger and saying, we're not going to give this individual no more overtime. And that's producible, it's in the record, and there is not much of a defense when we see something like that. So that is really critical. So we have not yet seen that uptick in New York yet. It just isn't there. So all we can do is read the statute and anticipate. We do, however, have the benefit of New Jersey and their whistleblower statute, because they're ahead of us in New York. They had a very similar statute, and it's the Conscientious Employee Protection Act, otherwise known as SEPA, which is why I can't say it, because I just refer to it as SEPA. That is now one of the broadest whistleblower statutes in the country. and a tremendous amount of employment litigation in New Jersey is based on some of these provisions. And so what can we learn? When they expanded their whistleblower statute, because it was originally narrow in its drafting like New York. And I apologize, I've been talking all day and my voice is getting a little raspy. Okay, so section 740, which is the New York statute, as amended, resembles SEPA. It eliminates the requirement of an actual violation, requiring instead only a reasonable belief. That is critical because the employee can be wrong, right? So let's think about that. Employee complains, some rule or regulation of which there are hundreds, if not thousands, at this point, and they're wrong. And a manager says, we're fully compliant with the law. The way you're thinking about this is not correct. That employee continues in their belief, continues to complain. What are you supposed to do? What you should do is really take the time, show them the law, show them the regulation, talk them through it, get your company counsel involved, possibly, to provide some assistance in explaining it. It is really important to persuade that employee that the company is acting appropriately. This is one of the rare instances, if the only instance, that I really say that, or just go really spend that time, because the law is so broad. I mean, it really is just to some extent terrifying what we could see. So, you know, in the discrimination world, right, intent doesn't matter, right? It's the behavior that matters. You know, in some respect, this is analogous in that it just has to be a reasonable belief as opposed to an actual violation. And that's such a lower standard than the prior to the amendments. New Jersey courts have also required the existence of a substantial relationship between the conduct that is being complained of and the allegedly violated law. So a little bit of help, they've got to say, okay, what is the behavior that they're saying violates the law? Would it actually violate the law? There does have to be some nexus there. And based on some of the similarities in SEPA to Section 740, we would expect at least some level of consistency in how the New York courts are going to interpret 740 to that the statute in New Jersey. The retaliatory action. So the scope of retaliatory action covered by Section 740 is actually likely broader than under SEPA. And the reason is that while New Jersey requires an adverse impact on an employee's compensation or rank, or an action virtually equivalent to discharge to qualify as a retaliatory action, 740 in New York also includes actions or threats that would impact a former employee's future employment prospects. So there's some distinctions there between New York and New Jersey, where New York is broader. New York, it doesn't have to be related to compensation or rank or equivalent to discharge. It's much broader than that, right? We talked about suddenly having a performance improvement plan in place, you know, kind of out of the blue. So those are some key differences there. Here's some cases that we examined in New Jersey, trying to be prepared for when the New York, we start to see some cases here. So in Abamount, the New Jersey court established that to assert a claim under SEPA, a plaintiff must have an objectively reasonable belief at the time of objection or refusal to participate in the employer's offensive activity, that such action, so their objectively reasonable belief must be that such activity is either illegal, fraudulent, or harmful to the public health, safety, or welfare, and that there is substantial likelihood that that question activity is incompatible with that, whatever that law is. So that's a little helpful. New York is a little broader than that, but making that connection and a requirement is a little bit helpful. In the Macerano against New Jersey Transit case, there a plaintiff transit worker alleged she suffered retaliation after notifying management that documents placed in a recycling bin were accessible to other building tenants. The court determined that the employer's disposal of documents was not a clear violation of the law. And so the conclusion was that the plaintiff's belief of a violation was not reasonable nor objective. On the flip side, in a case against the Associated Humane Societies, there the employee of a not-for-profit alleged retaliation after objecting to the employer allowing an elderly woman to adopt a dog meant to be euthanized for biting a previous owner. Here the court held that they're not sure that it violated a law, but the employee was objective and reasonable in believing that the adoption of the dog would be harmful to the public health or welfare. So these are just a couple examples of cases that are out there. Look at, these are not serious major laws that are being alleged to be violated. It's, you know, placing documents in a recycling bin that some other tenants might be able to see. And here, while certainly, you know, danger if there's a dog that has bitten another person, but these aren't, you know, major laws, and claims were filed. So we are anticipating these laws. In fact, we have a client right now in the pharmaceutical industry who had an employee who objected to taking certain actions that they believe would violate rules and regulations promulgated by the FDA. And this is all in writing. They put it in writing, a report on why they didn't think that the company was being compliant. And with respect to recommendations on a drug, the employer felt that they were completely compliant, put incredible pressure on that employee to change their position. That employee refused. They actually then, without consulting their employment lawyer, which was not us at the time, and they actually issued a negative performance review for that employee's refusal to change their opinion. That employee then resigned, saying, I obviously cannot do my job here, and we're just counting the days for that, because that is an absolutely valid claim under New Jersey SEPA. That's exactly what it's intended to do. You know, hopefully the employee does not want to bring a claim, but we'll wait and see. But that is clearly an example of a company believing they're right, but not understanding that even if the employee is wrong, they still should not have disciplined that employee for that belief, because it was clear the belief was reasonable. They may have been wrong. I actually don't know whether that employee was right or wrong. But it was absolutely reasonable for the employee to take that position. And that's a, you know, a major case that could be filed. So we're waiting to see. As I told the client yesterday, every day that goes by without that lawyer letter is a good day. We'll keep our fingers crossed.
And do you want to pause for a second? Does anyone have any questions at the moment? Okay, here's one right here. Do you anticipate claims relating to COVID-19 vaccine mandates and return to office?
Yeah, great question. 6 months ago, I probably would have quickly said yes. I don't know. It's there's still a vaccination mandate in New York City for some employees, some industries, some governmental workers, and I don't know. There has not been a tremendous amount of COVID-related litigation, and I don't have a good handle on why. I think there's real potential exposure for many companies. And I don't know why employees or lawyers, by the way, because oftentimes lawyers will go out and try to actively get clients to bring certain claims. And I would think there would be. I just don't have the answer, and there hasn't been. So my answer today, so 6 months ago, I would have said yes. I would have been wrong. Today, I'm going to say no, that I just, at this point, I don't see it. But again, I was wrong. I would have been wrong 6 months ago on this. And, and we don't know, as we see the cases rise, certainly we don't need to get it into a debate on COVID. Everyone has so many different thoughts and opinions and feelings about it. But cases are on the rise. I have not seen any of our clients reduce their in-office requirements, days back in the office, interestingly enough. So even though I know today in the paper, I read that I live on Long Island, so I pay attention to Long Island a little bit more than those who do not. The positive test rate is now just under 10%. When that was 10% in like November or December, people were panicked. Offices were shutting down. So it's different today. Obviously, mortality rate, hospitalization rate, there's a lot of other factors. So that just leads me to believe for the moment that there won't be. That being said, I would just make sure that you're compliant with whatever rules may be out there. And then with those rules, that policies that you have in place, whether it's, private employers can mandate vaccine for employees, or when you should wear masks or not wear masks, make sure that that is applied consistently. It's not easy. The government has changed their policies. There's inconsistency out there. So it hasn't helped employers at all. But it's really the one area where there's inconsistency and the law isn't clear. Usually that's the best example is in the health and disability space, disability discrimination law, where the law is very complicated and difficult to comply with fully, as you're trying to figure out, can someone work at the job with or without a reasonable accommodation, getting a doctor's note, analyzing yourself, what can they do, can't they do, how much time can they spend off, can you discipline them for, really difficult. That leads to litigation. For some reason, this area hasn't. So long-winded answer, but excellent question. So here's another question.
All right, let me jump in. Was thinking of whistleblower claims if employees objected to return to office or hybrid schedule, did return and there are subsequent performance issues?
Yeah, I would say really companies have a lot of flexibility there to determine your in-office schedule, hybrid schedule, who can work in the office, who cannot work, who can work in the office or required to work in the office, who can work from home. So there really, I think there's a lot of freedom there. I don't really see any law, rule, or regulation in place. So if someone, you said we're going to be 3 days in the office, and someone said, well, I don't feel safe, right? There are some, you got to make sure there isn't a real health issue. I mean, you have to go down that path. But if there isn't, I just don't want to commute to the city. You have, you should behave in the way you would normally take whatever actions as you normally would take without relation to a concern about a whistleblower claim. I don't see that being an issue that I would be concerned about a whistleblower claim. The issue in that is just making sure, with vaccine mandates, it was the religious exemption and health-related exemption, the same thing, if someone can't come back to the office, do they have a health-related reason why? Are they, in a group or have a condition where they are susceptible to serious illness from COVID? That's what I would be focused on, if that makes sense. But I don't see that as a whistleblower issue. Okay, let's turn the page. Okay, so we're still talking about New Jersey just because we're trying to use it as a measuring stick for the New York claims under the New York law, and trying to draw some information that might be valuable in protecting ourselves against New York whistleblower claims. If you're from New Jersey, then obviously this helps directly. In order to establish a case under SEPA, there must be a direct causal connection between the whistleblowing activity and the retaliatory action. There can either be direct evidence or inferred connection based on the surrounding circumstances. Timing is one of the most important aspects and some of the best evidence. Again, in almost all of the retaliation type claims that are out there, timing is really important. So in the Planters Lifesavers case, there was a 2-month gap between the protected conduct and the adverse action. So an employee complains about some theoretical violation of a regulation, and then 2 months later, there's a negative performance review when there wasn't one before. That's a short enough period of time that a court's going to say, hey, there might be that causal connection there. A rule of thumb for me, because the law is not clear, there's no formula. I always say more than 6 months, I feel pretty good about it from the employer's side. Anything less than that, as you get closer to the conduct of the employee, it's a greater risk. You can get different answers from different courts. I always like using 6 months as a rule of thumb. So you say, well, I was going to fire this person, but there's this potential issue. I like waiting 6 months when you can. That doesn't mean you always can do it, and oftentimes you can't. There's a business reason that is imperative, and you just can't wait the 6 months. It's just a greater risk. And New York, by the way, as I indicated, it's not just in New Jersey. They followed similar timing tests with respect to adverse employment action in many of the different areas of law. And in fact, we actually think that it's going to be one of the most important components of a valid retaliation claim under the New York statute is the timing element. So always be careful if you need to take an adverse employment action. Think about, has this person brought anything up that might fit under the whistleblower statute, which is new thinking, right? Never thought about that before. So keep that in mind. So let's now, some of this I'm sure I covered. Implications and next steps for employers. So there is a written notice requirement to make sure that it is visible wherever you're posting it. You can have it posted on an intranet or wherever you would post written notice requirements if you have a remote environment as well, which nowadays many companies do. Review your existing policies and procedures regarding the management of employee complaints. That is critical. Many mistakes are made. What is a complaint? One of the biggest questions I hear, or things I hear from clients, well, really, it wasn't a formal complaint, so we didn't do anything. I don't know what that means. I think that comes from like the 1950s employment law. Any employee who says anything that could be construed as a complaint to any manager at any level, that needs to be taken very seriously. So make sure you have all the appropriate policies in writing. Employees know how to make complaints, but then just as important is what does the company do? A complaint is being made, and what's supposed to happen. So you need to have a policy in place so that everyone understands what is to happen. And then you need to train the people who are handling the complaints. Another really tremendous problem area is when you have managers who are not trained in handling complaints, doing investigations, handling the complaints. And it is a unique skill that has to be done properly. The different laws where you do investigations or handle complaints, they're not all the same. So they now need to be trained about this whistleblower statute and what would constitute a complaint and then how to handle it. Really important. And then, see below, train managers and supervisors. Teach them what the law is, right? Have them understand how broad it is, how broad the definition of an adverse employment action is under this statute, because it is going to be utilized, as I've said. There's just no doubt in my mind. Okay. So here's some of the notice requirements. You can go to the link there. There's a model notice for employers. Always good to use the model notice, and that the government can't tell you it's not appropriate. So when and just make sure you're thinking through if employees aren't coming to the office, how are they having access to that notice? Important as well. Okay. Just trying to see if there's anything new here. So this is what we talked about. One of the most important rules in employment laws, right, is uniformity and consistency, right? Treating everyone the same to the best of your ability. So how complaints are reviewed, who's reviewing them, administering adverse employment actions. It's really important. I am repeating myself because it is that important. That you focus on all of these issues. I apologize for losing my voice. We're this is Roger. Maybe I should be doing these in the morning.
You know what? It's like it's still, even though it's warm outside, it's still pretty dry air.
Oh,
I've
man,
got
sorry.
the humidity meter in the house, and it's only at 23% for indoor humidity. So it is it's still pretty dry out there. We've not really hit our our spring humidity. Or here's a question, reposting. Visibly, it says prominently posted for various legal postings for hybrid employees. Would electronic posting only be acceptable? My understanding is that this is not resolved.
Yeah, good question. My advice is in a hybrid environment where employees are coming to the office, post it where you normally would, where people go to and they see it, right? It doesn't have to be seen every day, right? So that I would, thanks for the question. I would, for the hybrid employees where they come into the office, whatever that room is, the back dark lit closet. I had a client once who I went there for harassment prevention training. And I do like to physically walk the space. Had a client, and they did a little tour, and I said, where do you have your notices, employment notices? And like, oh, follow me. And it literally was in a utility closet where they had some like cleaning equipment, and it was posted in there. And I was like, this is not going to work. You can't. You should not have these notices in a utility closet. Anyway, just made me think of that. But that's the advice is keep it. Do not do it just digitally. I just wouldn't do. If you can do both, that's fine too. If particularly there are some companies that have fully remote and hybrid. And a hybrid environment, depending on the type of employee. So you can do that. Apologize for my phone there. I have to figure out how to mute that. Do not disturb. I think I just did that. Okay. Let's move on. I'm trying to keep us to an hour. I think
Yeah.
Fair in these
times.
Yeah.
We have one other question from Barbara again. Can you comment on federal whistleblower requirements?
Yeah, not in particular. I can just touch on there's some federal statutes dealing with actual fraud and where you're defrauding the government. There's potential claims. There's obviously Sarbanes-Oxley. There's some whistleblower potential there where there's with the SEC, public companies, because there's a different set of rules. There's whistleblower protections there. But I don't really have much more to say. If you have a very specific question, I might be able to answer it. But I don't get involved tremendously with public company work in full transparency. Okay, supervisor training we've talked about. So, please make sure you're doing that. That is the takeaway, right? Training. That's going to minimize risk here. And if you look at Romanet 3 here, make sure that you really have a good written record. If an employee is making a complaint about the potential violation of a law, there's an investigation. Make sure you're keeping a record of that investigation, witness memos, conclusion. And then ultimately, if you're taking any disciplinary action, you want to make sure you have that properly papered so you can show that it did not have anything to do with the complaint that was made. So here, having a full written record is critically important, because the standard for bringing a claim is so low, right? When an employee can be wrong and they just complained, I mean, unless it's completely ridiculous, but they can be wrong. And then if you take action, because they kept harassing you, they were at it, they wouldn't shut up about the issue, and some mid-level manager disciplines them for that, that's a claim, potentially. So you really need to keep a written record and make sure that you have those memos and notes to show your attorney in the unfortunate event that there is a claim that's made. So Roger, I think I'm going to end on that, unless anyone has any questions.
Feel free to dive in here and ask your questions, folks.
And what I will say, if something comes up that you're like, oh wow, that would have been a good question, please, here's my email address. Please feel free to reach out. I'm happy to help in any way.
Yes, we'll do. Apologies for anyone who had issues logging on today. Apparently, the one of the links sent folks to our homepage rather than the Zoom page itself. Always never.
That's a conspiracy, Roger.
Never-ending fun with technology. It's a conspiracy of the wrong kind. We want our people here.
No, and thank you, Roger, for inviting me. I do appreciate it.
You bet. And if anyone did not receive their invite from us directly, and you'd like to be part of our regular distribution list for HR roundtable presentations, just let me know. I'm going to pop my information into the chat window so that you can reach out to me directly, and we will get you onto the distribution list so that you receive your HR roundtable invitations. We try to mix it up here. We try to make sure that we're covering all of the employment law of the day, as well as other issues that affect everyone's workplace employee relations issues, and then just other topics that are things that are of interest to the HR community. Always with an eye towards arming you with what you need to get your job done, as well as some facts to back yourself up when you are trying to advocate for all the HR initiatives that you would like to have done, and you sometimes need to make a real case for. So we try to give you solid information to back up your argument and go march up the mountain with. And with that, I think we will, if we have no further questions, then I thank everyone for attending. There are SHRM credits available for the session. For everyone who attended the full session, you will get an email with the code for that, as well as a link to the recording of this session that you can share with others within the company. And we thank you. And Andy, thank you so much.
No, appreciate it. Take care, everybody.
All right, very good. Walter, take us out.